Folks, with Tasseless today, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about how ideological concepts of social power and group social power have infiltrated, subverted, permeated the law, or the practice of law, I should say, rather than its codification, but how policy, government policy or corporate policy has drifted away from the actual codified law that is practiced in a court. And now there are really dual systems of law, two-tier justices, we call it. And this relates to social power. So it washes up like this, that if someone has a lot of social power, the straight white male, and this is ideologically determined rather than actually determined, but if you're from a high social power group, then you should have, it is only the right thing to do ideologically, that you should have fewer legal rights. If you have high social power as a group, then you should have fewer legal rights. That is just, it is fair, it is reasonable. Now, how such insanity could have crept in, we can maybe talk about that in another video, but that's really the upshot of it. The reverse is also the case. If you come from a low social power group, again, ideologically determined, then you should have more legal rights. And then you should have what are known as trumping or overriding legal rights. That is, if you're in legal contest with someone from a higher social power group, you must, the court must give you the legal victory, because that is then produces an ideological vision or view of social equality, equal outcomes, all that sort of stuff, equity. So now none of this is codified in law. So you may ask, well, if it's not codified in law, how did it happen? Now, legal colleges, jurisprudence schools and so on, even in the Ivy League, have certainly in the last 25 to 30 years been teaching this idea that really social power is a thing. And okay, we can't really define it. Sure, we can't really codify it. And even to codify it would be illegal. The Constitution simply wouldn't allow it. So what we'll do, we'll just practice it. This social power gig, we'll just practice it in parallel to the actual codified law, but we'll actually give the social power ideology supremacy in the courtroom. Now, there's a case in the United States where, and I'll give you the quick version here, where a white woman was denied a promotion on the basis that she wasn't a lesbian. It's kind of a gay lesbian cabal is running the place, and they were only promoting gay lesbian people in some sort of perverted notions of its equity, and we're compensating for what happened thousands of years ago, and so on. And so, strange sort of ideological subversions and perversions of things, of reality. And so they denied her the job. Now, obviously, powerful forces are supporting this woman, and she took it to the court, and they effectively supported the policy that the government department was taking, saying, well, you're white, you kind of got social power, so really they gave the job to a brown lesbian, so hey, what's the problem here? We're only talking equity. You can't prove that you're discriminated against because you have social power, and because you have social power, you need to have 100 witnesses that say that you were discriminated against. Now, if you're a brown lesbian being discriminated against, or a black lesbian, you don't need any witnesses. You need only assert it. But there's a much higher bar you have to meet because you have social power. Now, straight away, there's a problem there because that's not codified in law. Hey, guess what, white person? You got social power, so your witnesses don't matter. You can't codify that in law. Because it wouldn't be law anymore. It would just be the mad ravings of some gender studies student out of some bullshit college. But it's actually ended up as practice in legal fraternity, and no one seems willing to put an end to it. Judges that don't go along with it find themselves ex-judges. There are media hit pieces come around chasing them out of the courts and this sort of thing. So really everyone sort of had to go along with it, because that's kind of how things were. Now in courts that are courts that are, say, factual law or things like that, contract law, that sort of stuff, then that probably wouldn't really come into it that much. But in things like discrimination and offshoots of that, then ideology reigns supreme. Or where there's conflict between, say, rape cases where it's him against her, and those sorts of divorce cases, or anything that involves race conflict or gender conflict or sexual orientation conflict, then the invocation of ideological law, as in social power, that then decides the outcomes. Now, it's commonly known in the legal fraternity that if the straight white guy's in legal contest with the black lesbian, his lawyers tell him, for God's sake, don't come to court in a sharp suit. Come in, wear jeans that have got holes in it. Don't shave. Don't comb your hair. Don't go to bed at 4 a.m. so you're looking all bleary-eyed and put upon and downcast. That's the look you have to come into, because if you look like the sharp suit and the upstanding citizen, then you're the epitome of the guy or the person that has social power. So the judge will rule against you, not because the facts support that, but because you have, and are clearly demonstrating with the sharp suit and the sharp haircut and so on, that you have social power. So do the opposite. Drool, go into court drooling if you have to, but do not look like you have social power. So this is, given that it's so widespread in the legal fraternity, you wouldn't think that they would subscribe to it so strongly, but they do. And people are appointed as judges, brazenly so, on the basis that they subscribe to this nonsense of social power should decide legal outcomes. But this woman's taken the matter, this white straight woman's taken the matter to the Supreme Court, and the Supreme Court's hearing it, and the argument is, should we all be equal under the law, that there is no such thing as social power or designations of social power, or that it's relevant in a court case. It's not, or in the case of, say, someone being hired or promoted. If there are multiple rules for different groups based on ideological fanatics determining social power, randos because they can't define it, then that's not consistent with the Constitution. Everybody must be equal before the law, and the merits of the case are the facts and the evidence and so on. Now, you see this in court cases. Just a court case, this is some years ago now, there's two neighbours arguing over the fence, the dividing boundary line fence. One neighbour number one had handed the design of the fence over to neighbour number two. Neighbour number two said, "Yep, that's fine with me. Let's go ahead, pay half each." Now, when the fence builder came along, neighbour number two changed his mind and said, "No, I don't want the fence so high here. I want it lower over there." So changed the design of the fence. So when the neighbour number one saw that the fence, hey, that's not what I agreed to, and then wouldn't pay the fence builder said, "Well, you changed the design. It's an extra $500 for the screwing around. I had to get new materials and so on." So the neighbour number one said, "Well, look, I won't demand that you take the fence down, which is what I should do because it's not what I agreed to. But given it costs $500 extra, to use your design and not one we agreed to, then you have to pay that $500. But I'll pay the other. I'll pay what I agreed to pay." And so, anyway, neighbour number two said, "No, you have to pay half the $500 extra as well. And so, what if I change the design? Too bad." Da da da. And so anyway, the matter goes to court. So you'd think it'd be very clear that number one party, I mean, the matter that it would go to court is insane in the first place, that the court would agree to hear it is insane. But the neighbour number one argues, well, it's not what I agreed to. Here's the correspondence. Either you take the fence down and put up the one that we agreed to, or you pay the difference of the design, and so on. It went like that. But the judge the judge says, well, look, the guy who's neighbour number one's wearing a sharp suit, and he looks like he's whereas neighbour number two, obviously sus to how things work, turns up in the jumper with the holes in it, and the shoes that are falling to pieces, and looks like they just got out of bed. And so the judge just says, oh, well, to the guy in the suit, well, I don't know, you look like you can afford it. Why don't you just pay it? And the decision was made. What? You look like you can afford it. So the merits of the case be damned. So this sort of epitomizes the attitude in the legal thing. And you even see it in things like determination of alimony payments and things like that. If the alimony people add another zero or something, or another whatever amount to the alimony, and the guy complains, then it's not the merits of the thing. It's, well, you look like you can afford it, and so on it goes. So this idea of social power. Well, of course, we're going to promote the black lesbian. Don't you understand that black lesbians have been discriminated against for centuries? We're only just evening up the score here. We're only just delivering social justice. So what's your problem? But the point is the merits of the case and the facts of the case aren't being argued, which is what equality before the law means. And just the enormity of this, I think, escapes most people, that because of these social power stuff and these subversions of perversions that have occurred all over the legal system, and principally in, if not exclusively in, countries where the globalists have taken control. So it's obviously very much a globalist device for breaking up social cohesion and destroying social cohesion, and they know this. So, and you saw the same sort of thing in the communist countries, that social power. Those that were dedicated to or appeared to be strong supporters of communist ideology, for example, they were not only rewarded, but they would win legal cases against those who weren't. So those that were considered to be, say in case of Cambodia, people that wore spectacles were considered to be ideologically considered to be intellectuals. So they had to be killed off. But more importantly, they had to have their legal rights stripped away. Now, similarly, you see legal cases where, and I've seen this in court where this was a divorce case where look, Mrs. Smith says that Mr. Smith, you're a child abusing fascist Nazi. That's an accusation. No facts supporting it, no evidence backing it up, no witnesses, nothing. But the court will accept that as fact. We've decided that because she has so little social power ideologically, we're going to say that her claims unsupported are fact. Now, you may have 3 witnesses to say it's not true, but we're just going to raise the bar. Instead of 3, you have to have 33 witnesses that say you didn't do it or you weren't there, or So this idea of one side has to operate under a crushing burden of proof, whereas the other side, the one with presumably the ideological social power, can operate under much lower burden of proof. And this is what plays out in things like employment law. So the straight white woman goes to court, and they, well, you're up against the brown lesbians, so the burden of proof you have to meet is much higher. So you don't meet that high burden of proof. But where is it codified? Codified in law, you must meet. It isn't. It's just ideologically imposed. And this is the issue of ideological law running in parallel and running as superior to codified law. And this is the matter that the Supreme Court of the United States hopefully will deal with. And then we can go back to a situation of law where facts and evidence are not hysterical notions of ideological social power can determine legal outcomes. You've been with Tassos today, your Pushback channel, and thank you for listening.